This conference will now be recorded.
Hello, my name is Chante Lasco, and I will be presenting on the cost of justice, the price of impunity, accountability for conflict-related sexual and gender-based violence in Central African Republic. I will be sharing with you findings that I have gleaned from my work in Central African Republic, supporting the effective prosecution of conflict-related sexual and gender-based violence. Now I will share with you my PowerPoint presentation.
This conference will now be recorded.
First, a brief background on the conflict in Central African Republic. Central African Republic, or CAR, has experienced non-international armed conflict between 2002 and 2015, with two intense periods of conflict from 2002 to 2003, and another period of conflict beginning in 2012. The more recent conflict beginning in 2012 has involved interreligious conflict between predominantly Christian and predominantly Muslim groups within CAR. These civil conflicts have resulted in widespread attacks against civilians. These attacks on civilians have included widespread conflict-related sexual and gender-based violence, or SGV. The UN reported that nearly all parties to the conflict committed acts of SGV. While the UN did gather a lot of evidence of acts of SGV, it also acknowledged the fact that this crime is underreported and underinvestigated, and thus the documented cases of SGV represent a fraction of the actual victimization. A wide range of acts of sexual violence occurred during the periods of conflict, including a high incidence of gang rapes, some involving up to 20 perpetrators attacking one victim. Many times rapes occurred in front of family members. In some cases, entire families were raped in front of each other. Victims included girls, boys, men, and women, people aged 5 to over 60. Victims were often targeted because they were perceived to be allied with an opposing party to the conflict based on their religion, ethnicity, or other factors. These atrocities demand justice, and there are several different accountability mechanisms that are being pursued to varying degrees. First, the International Criminal Court, or ICC. Second, the Special Criminal Court, or SCC. And third, other national courts in CAR. To begin with, we will look at the justice mechanisms dealing with the conflict-related violence in CAR at the ICC in The Hague. The ICC has been investigating both periods of conflict in CAR, referring to these situations as CAR 1 and CAR 2. CAR 1 dealing with the 2002 to 2003 violence, and CAR 2 investigating violence beginning in 2012. The more recent conflict beginning in 2012, known as CAR 2, that situation has not yet resulted in any arrests. However, in CAR 1, the first situation, the ICC prosecuted Jean-Pierre Bemba Gombo, known as Bemba for short, for crimes committed during the conflict in CAR. Bemba was the commander of the ALC, the Armée de Libération du Congo, the military branch of a political party within the Democratic Republic of Congo, or DRC. Bemba and his troops were welcomed into CAR by then president of CAR, Patasse, who invited Bemba's troops in order to help him quell a coup attempt within CAR. When the DRC troops came into Car, they committed widespread acts of violence against the people of Car. And as a result, Bemba was ultimately convicted at trial at the ICC for rape and pillaging as both war crimes and crimes against humanity, for failing to prevent or punish these crimes committed by his subordinates against civilians. Bemba was sentenced to 18 years in prison by the ICC. Thus, to date, Bemba has been the only person tried for crimes committed during the conflict in Car. But unfortunately, on June 8th of 2018, Bemba's conviction for rape as a war crime and a crime against humanity was reversed on appeal, and all of his other charges were also reversed. Thus, the only person held accountable for crimes committed in Car to date has now been acquitted of all charges. In addition to the blow that this has dealt victims of sexual and gender-based violence seeking justice for these crimes, there could be a ripple effect that could have wider implications for holding commanders responsible for the crimes committed in Car and beyond, because the appeals chamber in the Bemba case arguably raised the bar for holding commanders responsible for the acts of their subordinates, including acts of sexual and gender-based violence. Understanding that options for pursuing justice at the ICC are limited, both due to the mandate and the resources at the ICC, we must look to other justice mechanisms within Car in order to seek justice for victims of conflict-related sexual and gender-based violence. The first mechanism within Car is the Special Criminal Court. This is a court created by Organic Law 15-003 in 2015 to try war crimes, crimes against humanity, and genocide committed since the 1st of January 2003. The Special Criminal Court has primary jurisdiction over these crimes, and these crimes will be prosecuted and adjudicated by both domestic personnel from Car as well as international personnel from other countries. The court is supported by the UN and funded by voluntary contributions from UN member states. It's important to note that the Special Criminal Court has a limited mandate and limited resources, and therefore other courts within Car will also have concurrent jurisdiction to adjudicate crimes involving crimes against humanity, genocide, and war crimes. These crimes are all included in Car's penal code and therefore can be prosecuted in any of Car's courts. But this underscores the need for sufficient training and resources, not only for the Special Criminal Court, but also for the ordinary courts within the justice system in Car. Car's penal code does provide important provisions that can facilitate access to justice for victims of conflict-related SGV in Car. First, it does include crimes against humanity, war crimes, and genocide. And the crimes against humanity provision is important because it includes not just rape, but other forms of sexual violence as well. This provision is modeled after the Rome Statutes crimes against humanity provision at the International Criminal Court, which includes as crimes against humanity not only rape, but also other acts of sexual violence, including sexual slavery, forced marriage, forced pregnancy, and more, including comparable acts of sexual violence. Additionally, the definition of rape provided in Article 87 of Car's Penal Code is broad in nature. It defines rape as any act of sexual penetration of any kind committed on the body of another person by violence, coercion, threat, or surprise. This is important because the definition of rape is broad enough to encompass acts of penetration beyond vaginal penetration, to include oral penetration and anal penetration. This broader definition is important in order to prosecute the full range of acts of sexual violence that can constitute rape, including acts that are often perpetrated against men and boys. Now, acts of rape and sexual violence are not explicitly listed as acts that can constitute war crimes or genocide within CAR's penal code. However, under customary international law, rape and other forms of sexual violence can be prosecuted as war crimes and as genocide, despite the lack of explicit provisions listing these acts in CAR's penal code. Despite the fact that these these provisions within CAR's penal code provide for access to justice for victims of conflict-related sexual and gender-based violence in CAR, there are three specific barriers to victims' access to justice I would like to highlight. First are threats to victim security. Second, limited capacity and resources to pursue these cases. And third, the stigma associated with victimization. Regarding threats to victim security, this is a critical issue given the fact that 60% of CAR's territory is still controlled by rebel forces, which limits the government's ability to protect victims in these areas. Of course, this also limits the ability of victims to report the crimes committed against them, provide evidence, and have access to justice for the crimes that they have experienced. Continued violence and outbreaks of fighting threaten the stability of the country as a whole and the work of the court. It's important to remember, too, that the perpetrators of these crimes are, for the most part, members of armed groups. Therefore, they have weapons and are part of a larger network of armed groups that demonstrate a real threat to victims of sexual violence that report the crimes committed against them. Additionally, it's important to note the limited capacity in terms of resources, both human resources and physical resources that CAR is facing. First, the justice sector is under-resourced and was before the periods of conflict, and the conflict only inflicted more damage and further reduced the number of legal professionals within the justice system. In 2009, it was reported that there were only 2 criminal prosecutors in the capital city of Bangui, and the vast majority of all legal professionals were centered in Bangui. And yet there were only 2 criminal prosecutors at that time. In addition, the physical infrastructure, the actual buildings and equipment necessary to run a justice system are extremely limited in CAR. There are communities that don't have a functioning jail, that can't hold any suspects who are being charged with serious international crimes. And here in this picture, you can see a photo from an Amnesty International report of a court in Bangui, which is clearly a bare bones building, lacking a lot of the equipment and infrastructure necessary to provide certain protective measures to victims of all crimes, including victims of sexual and gender-based violence. Another barrier that victims face is the stigma associated with being a victim of sexual violence. This type of victimization is heavily stigmatized in CAR, and victims have reported that their husbands have left them, have taken their children away, their families have rejected them, and their communities have ostracized them. And this is a major reason that many victims do not come forward and report the crimes that they've experienced. And this prevents them from seeking justice for these atrocities. To respond to these barriers, there are three important steps. First, we need strong policies in place to help ensure victims' access to justice, as well as the support and protections that victims need if they do choose to engage in these proceedings. Policies include both strong rules for the courts protecting victims, as well as best practices and protocols used by the courts and victim advocates to complement the rules of procedure and evidence. Second, training is required both for justice sector actors and civil society actors, because all of the rules and best practices that are on paper will be of little use if those that must work to implement these policies are not properly trained in how to implement them. And finally, in order to ensure effective application of these policies, it's necessary to allocate the resources that are required in order to fully implement effective justice and protections. And it's necessary to have oversight in order to ensure that acts of sexual and gender-based violence are being investigated, are being prosecuted, and that in the process, victims' rights and protections are being respected. To review some of the policies or rules of procedure and evidence that are in place at the Special Criminal Court, there are some important provisions to note, including Article 46, which provides that the Victims and Witnesses Support and Protection Unit will provide a range of services and support for victims, including logistical, security, medical, psychological, and social assistance. And this provision recognizes the particularly vulnerable position of victims of sexual violence are in. Article 151 of the Rules of Procedure and Evidence also provides a lot of important protections for victims of sexual and gender-based violence. It calls on all the organs of the court to take the necessary measures to protect the security, physical, and psychological well-being, dignity, and privacy of the victims and witnesses and their relatives. Again, this provision focuses on the particular situation victims of sexual violence are in and their particular vulnerability. So what types of measures can be ordered to protect these victims? Article 151 lists several different types of protective measures that the court can order, including confidentiality measures that will remove victims' names and other identifying information from court documents and prohibit the parties to the court from sharing the names or identifying information of the victims. Additionally, it allows for victims to submit statements or provide testimony using special means that can hide their identity, including having their image distorted, their voice distorted, or even testifying using video conferencing or closed circuit TV, which allows victims to testify remotely. Additionally, the court can order the proceedings to be closed to the public during the testimony of victims of sexual violence. All of these measures are really critical to responding to the barriers of threats to victims' physical safety, as well as the stigma associated with being known to be victims of these crimes. Additionally, Article 151 allows the court to order a victim to be allowed to have somebody accompany them to court, a support person, whether it's a family member or a psychologist or another advocate in order to provide moral support to the victim. There are also some special evidentiary rules within the rules of procedure and evidence that are critical to facilitating victims' access to justice, as well as protecting their dignity and psychological well-being. Article 170 provides for considering a victim's situation at the time of the alleged sexual violence when determining whether an act that's at issue was consensual or not. The court must not infer that the victim consented to the act where that victim was in a coercive environment which prevented the victim from withholding or freely giving true consent. This is very important in order to acknowledge the coercive circumstances that usually accompany armed conflict situations and crimes against humanity situations in which victims are not in a position to resist or withhold consent to sexual acts. The silence or lack of resistance, therefore, on the part of the victim cannot be inferred to amount to consent to the act. Additionally, this provision states that the credibility, good repute, or sexual availability of a victim cannot be inferred from the victim's sexual behavior before or after the commission of the sexual violence. This is a common way in which historically victims have been humiliated and degraded and had their character attacked during trials. And this rule prevents such treatment of victims by making evidence about their sexual history inadmissible. Additionally, it's important to note that one rule many other international or internationalized courts have incorporated to protect victims' credibility is a rule that states you cannot require corroboration of the testimony of a victim of sexual violence. And the purpose of this rule is not to say that a court cannot find a lack of sufficient evidence to convict someone. The purpose of this rule is to require the court to view evidence from a victim of sexual violence on the same level as evidence from a victim of a different type of crime, because historically victims of sexual violence have faced harsher judgment and had their credibility called into question in a way in which that victims of other types of crimes have not faced. And this rule seeks to level the playing field for victims of sexual violence. Unfortunately, the Special Criminal Court elected not to include this rule that other courts such as the ICC, the Rwanda Tribunal, and the Yugoslav Tribunal included. And the Special Criminal Court omitted this rule. However, they could still follow this practice of considering the probative value of a victim of sexual violence, violence's testimony on equal footing as that of victims of other types of crimes. It's important that training be a core response to these barriers that victims face, because having the crimes in the CARS Penal Code and having the protections and rights in the Rules of Procedure and Evidence for the Special Criminal Court will not serve victims' interests if those entrusted with implementing these laws are not aware of these laws, are not educated about the importance of how to implement these protections and how to ensure that victims of these crimes have effective access to justice. It's critical that justice sector actors be trained in how to effectively implement these policies, as well as civil society organizations, which play a critical role in advocating for victims, supporting victims through the process, and pressing for justice for these crimes, as well as protection and support throughout the process. Finally, it's important to note that all of these rights and procedures are impossible without adequate resources. In order to fully implement the promise of the Special Criminal Court and the other courts within CAR, it's critical that the international community invest adequate resources in order to permit robust protective measures to be implemented in the Special Criminal Court and other courts, in order to continue training and other aspects of the support necessary. None of these protections for victims and none of these laws providing for access to justice for these victims will be implemented without outside assistance from the international community. Additionally, it's critical that the international community, as well as local civil society organizations within CAR, monitor the proceedings in order to ensure that victims' access to justice is being respected, that sexual and gender-based violence is being effectively investigated and prosecuted, and that through the process, victims' rights to protection and support are being observed and respected. In conclusion, here we have a picture of the inaugural hearing at the Special Criminal Court, which took place just this past October 22nd, a couple of weeks ago, while I was in Central African Republic. And this picture represents all of the promise that the Special Criminal Court holds for victims of conflict-related sexual and gender-based violence, and all of the opportunity that this court represents for access to justice for the crimes committed against these victims. But it is incumbent on all of us as members of the international community to play whatever role we can play in order to continue to support these victims and their right to justice. With that, I thank you for your attention, and I will end my presentation here. Thank you.